Hey, Amy Pittman here. I wanted to talk about what happens when you do not plan. So in our world, we're talking about estate planning. So if you do not consider what happens when you become incapacitated, like who's going to make your financial decisions or healthcare decisions, if you don't pre-arrange for that through a durable power of attorney, the designation of healthcare surrogate, then your family members will have to go to court to get a guardian appointed. And if you don't have any local family or family that you're talking to, then the state's going to likely appoint a stranger, someone that's a professional guardian that then has to go through the court system to get approved for paying your expenses and having access to your funds. So ideally, we're not going to want that guardianship to have to come into play because it's very expensive and it's very time consuming, and it's not like it's immediate. So by planning ahead, by doing your durable power of attorney, which allows you to name someone to handle your finances if you're unable to, yet you're still alive, and someone to make your medical decisions for you, you're providing peace of mind to your family or to your loved ones, or at least you're making sure that who you do have named is someone that you know and that you can trust to do things right when you're unable to. And then if you don't plan when you die and you don't have beneficiaries on your accounts, or you have assets that are just in your individual name, then that's going to go to probate. And if you don't have a will that identifies who receives those probate assets, again, those are assets that do not have a beneficiary on, then the state is going to determine who your next of kin is, or who that next person in line that's entitled to receive it. So there's a statute that identifies our next of kin, and that may not be who you want the asset to go to. So by planning ahead, by doing a will that identifies who you want your beneficiaries to be, should there be a probate, or by naming beneficiaries on your accounts, and you can do beneficiary designations at the bank. A lot of them call it pay on death. If you have an investment account, they usually call it transfer on death. So by doing a beneficiary designation, that is part of estate planning. So make sure if you have an account, whether it's a checking, savings, CD, money market, if you have a will and not a trust, then we always recommend that you have beneficiaries on it, with a few exceptions. Again, these videos are always just for informational purposes, not legal advice. You really need to talk to an attorney about your individual situation, but we want you to at least have that conversation. So go in educated. If you have assets that have beneficiaries, those do not go through probate. If you have a revocable trust, then we're going to tell you to name the trust as a beneficiary or as an owner of non-qualified assets. So again, by not planning, you're going to have your assets go to beneficiaries that are designated by the state. So it's an intestate statute that the state of Florida will determine who the next of kin is, or who that beneficiary is going to be. And again, that's not going to happen right away. So that's going to be a cost, and someone's going to have to go through that process for you. So definitely plan, whether that's coming to Pittman Law Office, especially if you're not local to us in the villages, then you need to go to someone that can at least sit down and talk to you about the type of assets you have. Will beneficiary designations be enough? Who you want to make financial decisions, healthcare decisions for you if you're incapacitated. I hope that helps.